Okay, I think we are ready. Why is this not looking right? Say that again. There. So let's get on the record, please, in Thomas LaVone et al. Versus FloShea at the point. It is a little after 9 on Thursday, the 16th. All our jurors are here. What remains for them is to receive the charge, which they will hear orally. It'll also be on the screens for them. They'll get a hard copy of what I'm reading to them during their deliberations. Oh, we don't have a verdict form yet. I didn't get a proposed verdict form from either side. I'm happy to put one together. I'll actually ask Ms. Niles to do that while I'm given the charge. But then both sides will need to take a look at that. I think because we're down to just the claims of the plaintiffs, it shouldn't be a particularly complicated one, but let's look. So it seems like, and we'll get it cleaned up, that it basically would be, we fine for the plaintiffs in the amount of X, or we fine for defendant. If you fine for plaintiffs, we find that punitive damages should be awarded. They don't come up with the punitive damages because we'd have to have part 2 of the trial. But I think it's that basic. Do you agree, Mr. Sterling?
I agree with that. Yeah.
Okay.
I agree.
Mr. Williams? Okay. All right. We can get something like that together and run it by you all. Mr. Sterling, is there anything else we need to cover before the jury comes in?
No, Your Honor.
Mr. Williams?
Yeah, Your Honor.
Mr. Sterling, did you and Mr. Williams go through all the exhibits and reach an understanding that, I'm guessing the pile that I see to my left is the collection of thumb drives that were admitted and all the paper exhibits?
We did, Your Honor.
Okay, and we've swapped out defense 1 for plaintiffs A?
We have, Your Honor.
Great. Mr. Williams, you agree?
Yes.
Okay, excellent. Then let's bring the jury in, please.
All around the jury.
Thank you. You're welcome. Be seated. Good morning, ladies and gentlemen. Welcome back. It's great to hear from you. We are ready to go with the charge. Looks like I messed up the screen because I had to, if I move that, does that go away? There. I had to send a message to my staff attorney. 2 things remain for you to complete your work. One is to receive the charge. I'm holding the charge. This is the law that I'm going to give you, and we'll talk about that in just a moment. After you receive the charge, you're going to go back into the jury room, and then you'll begin your deliberations. And ideally, that will yield a verdict that will resolve this dispute that has divided these parties for the many months. The jury charge is the law that you have to apply to the facts as you find them to be. There is law I'm required to give you in any civil case, and then there's law that's customized or tailored to the issues that have been presented by the lawyers in this case. I do my best to make the law that I share with you accessible, in other words, in plain language, but there are certain legal concepts that higher courts that I must obey have defined in certain ways. So I apologize in advance if some of the language I share with you seems stilted or overly formal. That's not how I normally interact with people. But if I use the wrong words in certain spaces, that's a reason for an aggrieved party to file an appeal. So I'm not trying to be highfalutin in the language that I use. I'm actually wanting you most of all to understand the law that you have to apply. You will receive the charge in two ways. I'll be reading it to you, so you'll get it orally. I guess you'll receive it in three ways. Second, it'll be on these screens. There's no bouncing ball, but as I'm reading along in each section, you will see what it is I'm reading. And then third, this document from which I am reading will go back with you during your deliberation. So don't fret if you're like, oh, conversion, trying to write down word for word what it is. You're welcome to take notes, the highlights for you of what conversion means, because we'll get to that. But what I'm reading to you will be with you along with all the exhibits. That's the stack of documents at the edge of the witness stand. You'll get a verdict form and you'll get this charge. So I only read it to you once, but you'll have it to reread as often as you want during your deliberations. So let me make sure I'm following along. There we go with what's happening. And does it move? It does move. All right, ladies and gentlemen, plaintiffs must prove their claims by what is known as a preponderance of the evidence. I think I can make that smaller there. That is evidence that is sufficient to incline a reasonable and impartial mind to one side of the issue rather than the other. If plaintiffs fail to prove their case, their claims by a preponderance of the evidence, your verdict would be in favor of defendant, but with no monetary recovery. Evidence is how facts are established or disproved. Evidence includes all witness testimony and exhibits admitted. It does not include opening statements or closing arguments, any questions that were asked, or anything else the attorneys or I have said. During trial, you were permitted to submit questions. The answers to those questions are evidence. However, you should draw no conclusions or inferences from the fact that some of your questions were not asked. Questions are not evidence, only the answers are. And of course, in considering the evidence, you are free to use reasoning and common sense to make deductions and reach conclusions. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, something like an eyewitness. I saw the car run the red light. I was standing right there. I saw it run the red light. Circumstantial evidence is proof of one or more facts that tend to prove some other fact by inference. If we had 5 people walk in right now with umbrellas and they were wet and they were mumbling about the rain, that's circumstantial evidence that it's raining outside. There's no direct evidence because you can't see out. There are no windows here, unfortunately, so you can't see if it's raining. That would be circumstantial evidence that it had been raining. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. You should not be concerned about whether the evidence you're considering is direct or circumstantial. When a party has evidence that proves a claim and the party fails to produce it, or having more persuasive evidence relies on weaker evidence, a presumption arises that the claim is not well-founded. Similarly, when a party has evidence that disproves a claim and fails to produce it, or having more persuasive evidence relies on weaker evidence, a presumption arises that the claim is well-founded. These presumptions may be rebutted. You, and I talked about this at the beginning of the trial, so this should sound familiar, you must determine the credibility or believability of the witnesses. In doing this, you may consider all the facts of the case, the witnesses' manner of testifying, the probability of their testimony, and their interest or lack of interest in the outcome of this case. In determining credibility, You may also consider evidence offered to attack a witness's credibility. This can include evidence of a prior inconsistent statement and or bias for or against a party to this lawsuit. Credibility may also be attacked by disproving facts to which a witness testified. A contract is an agreement between parties for the doing of some specified thing. That would be that legal language no one says doing, but that's what we define a contract as. It's an agreement for the doing of some specified thing. To constitute a lawful contract, there must be, number one, parties who are able to contract. 2, consideration, which is usually payment. 3, agreement to the terms of the contract. And 4, a lawful subject matter. You can't make a contract to assassinate someone because it's not lawful to assassinate. Parties may modify the terms of a contract through their course of conduct. A party to a contract may rely on the course of conduct modification to the extent that the parties regularly conducted business with each other consistent with that modification. The party's course of conduct can also operate to waive a requirement in a contract that all modifications be in writing. Evidence of a tenant's repeated, late, irregular payments, which were accepted by a landlord, is a factor for your consideration in determining whether a contract has been modified. When parties to a contract, through their course of conduct, depart from the contract's written terms, before either party can recover for failure to follow the written terms of the contract, reasonable notice must be given to the other party of the intention to return to and rely upon the written terms of the agreement. The departure from the terms of the contract must have been substantial and continuous, such as to make it unfair for one party to demand, without notice, all past due payments or to otherwise take action under the contract. The relationship of landlord and tenant is created when the owner of real estate grants to another the right to possess and enjoy the use of such real estate, either for a fixed period or at the will of the owner. A valid lease must identify the parties to the lease, identify the property, the consideration, the payment, and the terms of payment. There must also be an acceptance of the terms by the tenant. A landlord is under no duty to inspect the rented premises in order to stay informed about their condition, and cannot be held liable for damages caused from defects in the rented premises occurring after having parted with the possession, in other words, having rented it out, unless the landlord has been notified of the defects and has had a reasonable time in which to make the repairs. If a landlord is obligated under the terms of a lease to make certain repairs, if the landlord has been notified of the need to make such repairs, and if the necessity for repairs was not caused by the tenant's negligence, then if, after notice of the need for the repairs, the landlord neglects to repair within a reasonable time, the tenant has the option of making necessary repairs. It's a bunch of ifs that you'll need to unpack as you conduct your deliberations. If the tenant chooses to make the repairs, the tenant may recover from the landlord the reasonable expense incurred, or may set off the expense, that is, subtract from rent. If the tenant chooses not to make repairs, the tenant may seek compensation in an action for damages. A landlord may contract with a tenant to avoid the legal requirements of dispossessory or eviction proceedings when renting commercial property. If the terms of a commercial lease empower the landlord to re-enter and take possession of the premises without recourse to legal proceedings, she may do so and effect a self-help eviction if this can be accomplished without a breach of the peace. Conversion. When someone wrongfully asserts control over another's personal property and deprives that person of possession of the property, it is a conversion. To prove conversion in this case, the plaintiffs must show, number one, that they had a right to immediate possession of the property at the time they brought their claim. Number two, that the defendant's possession of the property was wrongful. And three, that the plaintiffs had demanded possession, but defendant had wrongfully refused to surrender it. The plaintiffs also contend that the defendant violated the law by its conduct in this case. That law that had been violated being the prohibition against theft by taking. Such a violation in a civil context is called negligence per se, which means negligence as a matter of law. It is your duty to decide whether such a violation took place. And theft by taking is defined as follows. A person commits the offense of theft by taking when he or she unlawfully takes, or being in lawful possession thereof, unlawfully appropriates any property of another with the intention of depriving him of the property, regardless of the manner in which the property is taken or appropriated. Damages are given as compensation for injury. When one party is required to pay damages to another, the law seeks to ensure that these damages that are awarded are fair to both parties. If you believe that plaintiffs are entitled to recover, you should award plaintiffs only the amount you believe is reasonable and just. Plaintiffs bear the burden of proof with respect to damages. They must prove each item of damages with reasonable certainty. You may not award any damages which are speculative or based upon mere guesswork. In some cases, there may be aggravating circumstances that warrant the awarding of what we call punitive damages. Before you may award punitive damages, plaintiffs must prove that defendants' actions showed willful misconduct, malice, or that lack of care that would raise the presumption of conscious indifference to consequences. Plaintiffs must prove that the defendant is liable for punitive damages by clear and convincing evidence. This is a different and higher burden of proof than preponderance of the evidence, which applies to everything else we've been talking about. Clear and convincing evidence is evidence that causes you to firmly believe each essential element of the claim to a high degree of probability. Ladies and gentlemen, by no ruling or comment that I have made have I intended to express any opinion about the credibility of witnesses, the evidence, or which party should prevail. One of your first jobs when you get back in the jury room will be to select a foreperson who will preside over your deliberations and who will sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your colleagues. Whatever your verdict may be, it must be unanimous, in writing, dated, and signed by your foreperson. And I'll get you a verdict form that lets you do all that. You write your verdict, someone, your foreperson, will date it and sign it. Your verdict should be based upon your opinion of the evidence according to the laws I'm giving you right now. You must consider the facts of this case objectively, without favor, affection, or sympathy to either party. This is a bulky paragraph, but I tried to fit it on one page. If you find that the plaintiffs are entitled to damages, you must determine an amount to be awarded. It is improper to agree in advance to be bound by the figure calculated by each of you, writing down your own figure, then adding all 12 up and dividing by 12. If you wish to use this method to arrive at an amount for discussion without binding yourself in advance to accept the result, you may do so. And you are not prohibited from accepting that result and adopting it as your verdict after that amount is determined if you believe from a preponderance of the evidence that the figure arrived at by this method represents just and adequate damages. However, you must first have found that plaintiffs are entitled to damages, and you must all agree that the amount represents your verdict after the amount has been determined. Only 2 more charges. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any outside research. That rule applies with added force while you are deliberating. You have all the evidence that you're going to get in this case, and from that, you must attempt to reach your verdict. It would be improper to supplement the evidence with any outside information. And this part's not on the screen, but hear me now. Deputy Gordon will be collecting all your electronic devices. So it will be easy to resist the temptation to do any outside research because you can't. We'll take your Apple Watches, your phones, your tablets, your computers while you're deliberating. I promise we'll return them. If we didn't, that would be conversion. So you'll get them back. But we keep them and they beep and make funny noises in my chambers while you deliberate. That way we just avoid the, look, what does that mean? Finally, during your deliberations, should you need to communicate with me for any reason, it needs to be in writing. So you can write it on a page from your notepad, on a handy dandy note card. Deputy Gordon will get that to me. I will then confer with the lawyers and share with you whatever response I am allowed by law to give. So my final editorial observation, you may ask a great question and I may have an answer that I think really scratches that itch, but it may well be that the law is, I can't help you with that one. And so you may get a response back that says, you'll have to rely on your collective recollection or reread the jury charge. That's not me being flip or difficult. It just means after I talk with the lawyers, they and I agree that's one you just have to power through. But sometimes I'm able to give you an answer that is exactly what you were. I mean, it may not be the one that makes you happy, but it directly answers your question as opposed to outlook not so clear from the magic 8-ball. I'm not trying to be vague, but there may be some things that you have to sort out yourselves. So you will have back there, as I mentioned, all the evidence. That will include the thumb drives. Obviously, you can't, unless you've got some strange bodily attachment I'm not aware of, watch those videos. If you want to watch videos or listen to things again, that's a note to Deputy Gordon. We bring all of you back out here, and with the lawyers present, we press play. You can watch it or listen to it as many times as you want, should you need to review that again. All the paper evidence, you'll be fine to review in the privacy of the jury room. So I'm going to ask you all in a moment to go with Deputy Gordon. He will collect your devices. Hopefully it's not going to be a physical struggle, but he'll collect those. We'll hold on to them. And Mr. Yas, I need you to stay where you are. The other 12, please don't start your deliberations. You can pick the 4-person, but until we deliver to you the exhibits, this charge and the verdict form, you shouldn't start. Okay? Everyone go with Deputy Gordon. You can be seated. Sir, our alternate, you are lucky 13. It was important that you were here very early every day to see and hear everything, because at any point up until they reach their verdict, if we have to excuse a juror, you will slot in as a co-equal. In fact, had it happened during the trial, we just would have been down to 12 and no one would have known the difference. If it happens now that deliberations have started, should you be parachuted in there, actually have to restart their deliberations because there's a new member of the group. We're going to set you up in a jury room over there. You get to keep your devices if you brought any devices. No outside research, though. You can read all about what's going on with Credit Suisse and things like that, but nothing about constructive eviction or landlord tenant, anything like that. We will not forget about you. There's a restroom in there, so you can take care of that kind of stuff. But if the group doesn't have a verdict by lunch and they break for lunch, it's your lunch break too. And you can actually spend time with them because they can't talk about the case during their lunch break unless lunch break is we're all eating in the jury room. And if they do that, we'll make sure you get lunch as well. But I promise we won't forget about you. It won't be 5 o'clock and you poke your head out and no one's here. If there is a verdict that's reached, once I've accepted that verdict, we'll bring you out. You'll get to know exactly what happened. And as I mentioned, it could be if something unfortunate happens, you become a part of the deliberating crew. Any questions? All right. If you've got anything in the jury room, you're welcome to go get it. And Deputy Gordon will get you into the other room.
Yeah.
That you or the juror? All right, counsel, there's the proposed verdict form on the screen. Drink it all in and let me know if you've got any edits you'd like to have made.
No edits from plaintiffs, Your Honor.
None for defendants.
I will hit print. I think I'll hit print. Cool. If you all can write down on one piece of paper, a single phone number for plaintiffs and a single phone number for defense. We'll call those numbers if we need you back in court and you're not already here. You're welcome to stay here. I don't have anything else going on today in court. So you don't need to relocate. You're welcome to stay right here. But you, if you should stray from the courtroom, need to be just a couple minutes away. Or you need to understand that as long as a representative, a lawyer, so it have to be Mr. Sterling, but someone from the defense team is here, we're going to go forward if anyone else is going to be more than just a couple minutes away.
I'm gonna go watch these closings next door, Judge.
Thank you. Here. That goes with the pile there. And was it only one thumb drive that goes back or all of them?
They're in there. It should be there.
No, I see a bunch of thumb drives, but only one of them has a sticker on it.
That's mine, Your Honor. We didn't.
Oh, they all go. Got it. Okay. So all the thumb drives. Bless you. That's not contagious. Got it? Excellent. 9:30. Okay. I will mute the microphone here so you guys can talk and it won't be pushed out into your fan base.
Thank you, Your Honor.
I heard you had a lot of views, Judge.
It's what happens.
I'll be number one.
Okay, yeah, that's okay.
You've been back to Sean's.
I did. I didn't read it. You might have been there a couple
Just kind of skimmed over it. I didn't look at the date or anything. I mean, I don't see anything that it's not.
Okay.
Okay. You ready? There is a question from the jury. I will read it as best I can. We understand there were two charges, one, conversion, and two, theft by taking. The verdict sheet only allows for one verdict. Are there two charges? Is there only one verdict for both charges? So we understand there were two charges, conversion, theft by taking. The verdict sheet only allows for one verdict. Are there two charges? Is there only one verdict for both charges? I didn't end up doing two things. First, Mr. Sterling, did you have any exception to the charge as I gave it to the jury?
I didn't have an exception, Your Honor, no.
Mr. Williams?
No, Your Honor.
Okay, that's number one. Number two, we had talked a little bit about how one might explain to the jurors that these are really charges in the alternative. I didn't express that. It wasn't literally in the charge, but I could have, had I remembered, said, look, there are two versions of the same alleged misconduct, that defendant took something that didn't belong to defendant, or defendant may have had a right to it, but misappropriated it in some way they shouldn't have. I think the answer to this is that the defendant is liable for one or neither of these, not both. So you could find the defendant liable for conversion or theft by taking or nothing, and the damages flow from whatever tort you find. I won't write it quite that way, but I think that's the right framework. Mr. Sterling, I'd prefer just to send a written answer rather than bring them out here, because I don't think it's a real complicated answer, but I want to make sure it reflects input from both sides.
Judge, I'd be fine with that explanation.
Okay, Mr. Williams?
Yes, Your Honor.
All right, let me draft something and I'll run it by you guys and then I'll put it on the card. What if I write on the back of the card, defendant is liable to plaintiffs for conversion or theft by taking or for nothing at all? Does that work for you, Mr. Sterling?
That's fine with me, Your Honor.
Mr. Williams? I can read it again.
Read it one more time. I think it's.
Defendant is liable to plaintiffs for conversion or for theft by taking or for nothing at all.
I'm fine with
It
that.
just gives them the three options. Write that as legibly as I can.
Judge, as I rethink about it, and I'm not sure of the answer, but I believe punitive damages would only flow from conversion, not from the negligence per se on theft by taking.
I don't know the answer to that, but we should figure that out. And then we may need to have a modified verdict form.
It's whether or not punitive damages are allowable under a negligence claim.
Yeah, I'm looking at this. Typically negligence cases don't have.
Yeah, I'm seeing that as well.
So I think we might have to modify the verdict.
Yep.
We would agree, Your Honor.
Sorry about that, Your Honor. I didn't catch that earlier.
No?
It was probably mine to catch that.
Right. Yep. No, a bunch of cases say that mere commission of tort of negligence, even gross negligence is not enough to support punitive damage awards. All right. So, it seems like the verdict form should say, we find that defendants let me work on it in a minute and then I'll share it with you. So let me show you a verdict form and see if that addresses that good catch. What do we do here? All right, if you look on your screens, it's the same header, but it basically trifurcates it. We find for plaintiffs on the basis of conversion, theft by taking, or we find, oops, let's get rid of the jury. We find for defendant, and then in all caps, if you find for plaintiffs on basis of conversion, then they look at the punitive damages piece, and that's the only time they should be looking at it.
I agree with that, Your Honor.
Okay.
We're fine with that, Your Honor.
All right. Can you, Deputy Gordon, please collect the verdict form that the jurors currently have and bring it to me, please?
So would your response to them just be, please see this new verdict form, or
I think I'll,
or just give them the verdict form, give them the new verdict form?
I'm gonna, what I wrote here is defendant is liable. Well, let me finish writing it. I'm gonna add one more sentence, which will say, see new verdict form.
Okay.
There's nothing written on the current verdict form, which I have collected, so they have no verdict form. They will soon have the one you see on your screen. Okay, so on the back of what I've labeled as Q1, I have written defendant is liable to plaintiffs for conversion or for theft by taking or for nothing at all. Please see revised verdict form, which will go out with the card. Any issues with that, Mr. Sterling?
No, Your Honor.
Mr. Williams?
There you are.
All right. Glad all this came to light. Thank you, sir. Anything else, Mr. Sterling?
No, Your Honor. Thank you.
Mr. Williams?
There you are.
All right. Okay, we are back on the record, and Deputy Gordon has informed me that the jury has informed him that the jury has reached a verdict. So if there is nothing else, Mr. Sterling from plaintiffs,
No, Your Honor.
nothing else, Mr. Williams from defendant,
No, Your Honor.
let's bring the jurors out, please. I'm going to hand you Court's Exhibit 1, which is the collection of all questions from the jurors during the non-deliberation portion of the trial. Okay.
All right, the jurors. Jurors are present.
Thank you. You all can be seated. You're the foreperson?
Yes, sir.
If you'd please stand. Have you and your colleagues reached a verdict?
Yes, we have.
Was it unanimous?
Yes.
And have you signed and dated the verdict form?
Yes, I have.
If you could give it to Deputy Gordon.
You.
If you would please publish the verdict, which means read it into the record. You don't need to read the style of the case, just we, the jury, whatever it is you find.
Okay. We, the jury, find for defendant.
All right. If you would hand the verdict to Deputy Gordon, share that with Mr. Sterling and with Mr. Williams. Mr. Sterling, do you have any objections to the form of the verdict?
No, Your Honor.
Mr. Williams?
No, Your Honor.
All right. Anything else, Mr. Sterling, before I release the jury?
No, Your Honor.
Mr. Williams?
No, Your Honor.
Ladies and gentlemen, on behalf of Mr. Sterling, Mr. Woodward, Mr. Wesley, Thomas LaVone LLC, as well as on behalf of Mr. Williams, his legal team, and FloShea at the Point, I want to thank you for your service. You were here a couple hours beyond what we had expected. You were always here on time. You clearly took this very seriously. And I think you understand now why some of these cases go to trial, that the two sides couldn't reach an understanding. In fact, they had a serious misunderstanding that led to a bunch of steps that got people pretty upset. But you have resolved it in a way that only members of the community can, not a judge, not the lawyers fussing at each other or anything like that. You saw a very well-tried and cleanly tried trial about which people were very passionate and for which they needed your assistance. And thank you for that. I'm going to have you retire to the jury room. A few things will happen. We'll reunite you with your alternate. We'll reunite you with your electronic devices. And I'll have letters for each of you if you want them, suitable for framing, that say you were here. If you need them for employers or anything like that, I'll have a few more comments for you, and then you'll be free to go. It may well be that the lawyers would like to interact with you, and they're free to do that. They'll stay here. And if you want to give them feedback or answer their questions, you can come back into the jury room. It is not obligatory. We'll get you quietly out of the building if that's the direction you want to go. But your next stop is back in the jury room, and I will see you shortly. Thank you so much. You all can be seated. So in no particular order, Mr. Williams, I need you to submit to Ms. Niles, but send a copy, please, to Mr. Sterling, a final judgment that would close out the case other than any appeals that might flow from this.
Of course, Your Honor.
And thank you, and Mr. Brickman, for your work. Mr. Sterling, thank you for your work. And Mr. Woodard, money wasn't going to replace what you lost anyway. I understand why you and Mr. Wesley are here and what frustrated you and what you've lost. I think Mr. Sterling very passionately and eloquently relayed that to the jurors. I'm gonna go talk with them. My guess is they thought the least controlled, but not that the two of you haven't suffered a loss from which you've rebounded, but you can't rebound because it was the intellectual property. It's not a dress, although it might have been someone's dress that they had been fitted for and paid for. But it's what you put into it, and that doesn't come back. And frankly, it wouldn't have come back with $5 million or $1 million, but there would have been different closure for you. So I appreciate that you pursued this in a court of law, and that you had a great attorney helping you with that. And Ms. Embry, I wish you and Mr. Flournoy the best with your continued real estate ventures. I trust that this was a learning experience as well, and that in the future, if there's a scenario like this, it may well work out in a different way, by which I mean nothing about your ability to exercise self-help pursuant to lease language that was clear and legal and the jury followed. But I think you now have heard a bit about how traumatic some of the losses were, not necessarily financially, but more creatively for your former tenants. And I wish both sides the best as they move forward in their different directions. Do the attorneys want to stay here? Because I won't have the, Mr. Williams is saying the defense side is leaving.
We're fine. We're not going to make them come back.
Okay.
I'm fine too.
You're fine too? Okay, then I'll let them know that I don't ever want you guys to have to ask. I'm always the one, because then they say, Judge, what are you doing? But I'll let them know that you all have things you need to do and you're going to be getting with your clients. But I appreciate the work both sides did. This went very smoothly. This comes on the heels of a 7-day water intrusion case that should have been a 3-day water intrusion case, but we didn't have Sterling on one side and Williams and Brickman on the other side. And the jurors, just by day 4, they were scraping their eyeballs out. So I appreciate the work that everyone did. And as I said, wish everyone the best as they move forward with things. Okay. Thank you so much.
Thank you, Your Honor.
Thank you.
Oh, and you all will take care of our court reporter.
Yes, of course.
Yes,
She
good.
knows where I live, so yes.
Thank you, court reporter.